do apologise that we're a few moments late.
Lady, of course, not at all.
Just really do want someone to do something with the file so that I can use it. Yes, Miss Gresham.
My lady, having said I would go straight to paragraph 9 of our skeleton, I just wanted, if I may, before doing that, to answer the suggestion made by Mr. Green on behalf of the father that what was being sought here was some species of third state return because the mother wasn't in Singapore anymore. Lady, the mother and child's immigration position was dealt with within the mother's evidence. She accepts that she was in Singapore on the basis of effectively a student visa that was granted to the child, and that her status there followed on from his. Her case is that the father made repeated efforts to cancel the child's student visa with the obvious aim of trying to get a situation where the child wouldn't be able to stay in Singapore. She deals, and it's not necessary really to turn this up now unless you would like to, but at page 384, paragraph 11 of the supplemental bundle.
384.
384.
Thank you.
The mother deals there with her and the child's immigration status. Which provides really a chronology up to, in paragraph 12, May 2020, where the court in Singapore had made an order to extend really the child's student pass. The mother then makes the point, which is obviously true, that when the child's student pass had been cancelled, it hadn't resulted in the mother and child having to leave. They had been able to remain, and then asserts that the fact that the child's student pass had expired as a consequence of him being retained here and kept away from his school wouldn't prevent them from re-entering Singapore, that upon re-entering the child could be re-entered into school and his student pass would follow.
Thank you.
And there is also, and again, no need really at this point to turn it up, but at 397 in the bundle is an email from the school that says, should the child be returned to the college, they would do their best to reinstate him in term 2 and reapply for the student pass.
Thank you.
So, the lady, my lord, in our submission there's nothing in this point. This is an argument that the father tried to run, that he has tried to engineer in the past through cancelling the child's student visa, an obvious intention to bring about a situation where the child couldn't stay. He's not been able to do that, and he's trying to re-raise it now to cast doubt on the mother's intention. But the mother has never sought the child's return to anywhere but Singapore, and she doesn't now. And on the basis of her evidence, probably really seriously challenged, I think, that can be done without too much difficulty.
Thank you.
So, lady, back to then.
Back to your skeleton.
Finally, back, paragraph 9 of the skeleton argument. And my lady was right to caution the intention of these submissions, but we don't raise them to try and challenge the decision as it was at the time, but rather because on our analysis and our submission, the history of this case shows the difficulties that can arise if proper steps are not taken at the relevant points in time. So when one looks at what might be the best course in cases of this type, one can look at this case and see where things have gone wrong and try to learn from that. And, lady, having set the scene, as it were, before lunch in terms of the situation as it was when the child found his way to Mr. Netto's door, that of course forms part of the background, but as I said, really I think was my last comment. None of that was known to Mr. Netto when he first laid the ground for this application. He discussed, as one can see from Mr. Netto's first statement with the child the question of influence and was given the instructions that he had not been influenced, that this was the child's own decision. Of course, there was no way that that could be analysed at that point in time because the evidence that shows, at the very least, a significant question as to whether those instructions were correct were not available to him. So that was the basis on which the first statement was prepared and put before the court. It is right to say that at that hearing in the mother's position statement it was asserted that there was evidence of influence, but of course it's very different, isn't it, having assertion made in counsel's position statement than it is to seeing the actual evidence as we now have it and can read it in the form of the very considerable number of messages sent by the father to the child over a period of years intended to try to get him to remain here. And just as that evidence wasn't available to Mr. Netto when he formed his assessment of the child's competence and decided to accept his instructions and to advance on his behalf an application to the court, it wasn't available to the judge when the judge came to decide that it was in this child's best interest to be joined. And that is relevant in our submission to the submissions made by Mr. Turner on behalf of the child about when the court should be considering this issue and whether it can really be right that it's considered effectively at the first hearing, that being the first opportunity. Because, of course, if it's done in that way, as my Lord Justice Moylan points out, the evidence at that point is usually very brief.
Well, there's a difference between considered and determined.
Yes.
It clearly has to be considered because of the need for expedition, and that's what the guidance says. But that doesn't mean it needs to be determined.
No. And there's a further distinction, of course, which is that what is required under that guidance is that the way that the child's voice will be heard is considered. And there are steps that the court can take to ensure that the child's voice is heard at that first stage. For example, the direction that CAFCAS should interview the child and provide a report as to their wishes and feelings. It doesn't mean that an application for joinder through a solicitor guardian, whatever one might term it, has to be dealt with at that point in time in the absence of any other evidence, particularly when there are clear, as I'm going to term them, red flags in a case highlighting the possibility of influence, and there were here. I mean, the fact that the solicitor was first contacted by the parent who has retained is a red flag in and of itself. But that is what happened here. The first contact with Mr. Netto was made by the father. So there must immediately have been a question as to how that had come to pass and why. But it wasn't really possible for there to be any more detailed exploration of that at the hearing in February because the evidence just wasn't there. And so, with the benefit of hindsight, the argument that that was an application that should have been put off to await further evidence, in my submission, was the appropriately cautious and correct one. And that approach is suggested also by the authorities, and particularly Practice Direction 16A at paragraph 7.2a, because of course the first thing we find there is that joinder may be indicated if there has been a recommendation by a CAFCAS officer. So one can have a direction for a CAFCAS report first. As quite frequently happens with older children, the CAFCAS officer can be invited to make a recommendation as to whether it's in the child's interest to be joined as a party. And the court can consider any application for joinder with that evidence available to it. But because it was dealt with straight away here, whether it was dealt with after lengthy consideration and a long judgment, although we don't have any judgment and the order doesn't make any reference to there having been one, or not, is neither here nor there, because the important aspect of all of this in our submission is that there were important pieces of evidence that the court should have been considering and were relevant to this question that were not available. One can see that really most clearly from the CAFCAS report and the terms of the CAFCAS report, because of course the CAFCAS officer deals fully and squarely with the question of influence, including in relation to how it was that the child came to find his way to a solicitor. And the particular reference to that is at page 457 of the supplemental bundle at paragraph 23. But of course the report is important in far wider way than just what it says about how the child came to find their way to a solicitor and to be seeking separate representation. There is a point in relation to that too, as regards the assessment of the child's competence in this context, because influence is relevant to that also. Now, this has engaged a question as to the boundaries of opinion evidence, because of course we see from the documents that opinion evidence can be advanced in relation to an assessment of competence. And of course that's inevitably so, isn't it? Because a solicitor takes instructions, discusses the issues with their client and forms a view as to their level of understanding and so on and so forth. And on the basis of the information they've gathered, advances to the court of view as to whether the child is competent to give instructions. So there must necessarily be an aspect of opinion evidence, but the ultimate decision as to whether the child is competent or not is for the judge, if there's a challenge in relation to that. The main relevance of that in this context, though, is that again, at the time when the decision about competence was made, there was an absence of evidence which would undoubtedly have been relevant. Mr. Netto's first statement appears to address that, because at paragraph 31, forgive me for a moment while I just find the page. It's in the supplemental bundle at page 142. The opinion that is advanced is offered on a provisional basis and subject to any further issues being raised in the proceedings.
Sorry, which paragraph?
Paragraph 31.
This is the same statements in the core bundle.
My lord, it probably is.
Okay.
I'm sorry,
No, so I just wanted to make sure.
it's internal page 8, paragraph 30.
Thank you. Yes. You're on the provisional basis.
Yes, and subject to there being any further issues raised in the proceedings. And of course, competence is something that can and should be kept under review. But what there isn't any evidence of in our submission is that that was so. One doesn't see in any subsequent statement after the messages that show such clear pernicious influence have been received, and in light of the Kafkas officer's report, which concludes and suggests that the child has been subject to influence, any review of that fundamental decision as to whether the influence that the child has been subjected to has an impact upon his competence or any other relevant aspect in terms of his representation. So, in all respects, both competence and best interests, in our submission, the decisions were taken about this child's involvement in these proceedings in this way far too early. And in the future, if this court is to give guidance about how applications of this type should be dealt with, the better course would be for them to be put off, really, to await full and proper evidence as to any influence or attempted influence, and particularly to await the Kafkas report. If that course is not taken, then it of course gives rise to a risk that the full picture in terms of the child's position will not be explored and put before the court. And in certain respects, it's our submission that that is what has happened here. And of course, in terms of the opinions that were advanced on the child's behalf, that was what the judge found, that the Kafkas officer had undertaken a full and proper assessment, particularly in relation to influence and the impact of that upon the child, but that the child's solicitor had not been able to do that. And if I can just touch on it then at that point, perhaps dovetails into what is our case on the point of principle here in relation to the role of solicitor guardians in the future and what evidence they are or are not entitled to advance. Now, in some respects, bearing in mind the way the judge dealt with this, that is not a point that's squarely engaged on this appeal. It's an important point of principle, but the judge here did not exclude Mr. Netto's evidence in any respect, whether opinion or fact or otherwise. He records within his judgment, and I'll go through certain parts of it in the time that I have left in a moment, that he wasn't invited to exclude any of Mr. Netto's evidence. What he did was to assess it, to decide what weight it should be granted, as against the Kafkas officer's evidence, in relation to which he performed the same task. And then, having decided that the Kafkas officer's evidence was of greater weight and substance, he preferred that evidence and used it when reaching his conclusion. But this is an important and significant question when one considers the fact, clear from all of the documents that have been filed with this court in preparation for this appeal, that the representation of children in this way is something that has continued and in fact probably increased in its frequency since the decision of Mr. Justice Baker as he then was in WF. The main issue as we advance it is the possibility, and of course this won't play out in every case, but the possibility for conflict between the roles and duties of a solicitor directly instructed by a child that they have considered to be competent to give those instructions, and the role and duties that are allocated to guardians of whatever type when they are appointed under the family procedure rules. And one can see that potential for conflict play out in this case in a way that I'll explain. Of course, when a solicitor meets with a child, decides they're competent and takes instructions, they are bound by those instructions. They act upon them and they advance them to the court. And one sees that in Mr. Netto's first statement here. He repeatedly makes reference to instructions that he has received from the child, including in relation to the key question of influence. But of course, it is also the role of a guardian to undertake an analysis and to offer that analysis to the court. In this case, when one considers the messages and the child's reaction as played out through the form of those messages to what his father was saying to him, it is at the very least, and this is really the lowest possible interpretation that in our submission one could form, likely that the child was influenced by what the father was saying to him, but actually, in reality, it is clear that the child was influenced by what the father was saying to him, hence the child's reference to feeling suicidal, to being hyperventilating and panicking as a consequence of what the father was saying. So it's plain that there was influence here. But the child's instructions are different. What is a solicitor who is playing that dual role to do in that scenario? And we know, including from the very helpful intervention filed by the Association of Lawyers for Children, what might happen in a public law case if that scenario were to arise. If there's a difference between the guardian's analysis of the child's position and the child's own instructions, there's a separation. The solicitor stays with the child, the guardian moves off as a reporting officer really, and the court can deal with them in that way. But that can't happen if you have a solicitor guardian. So the conflict becomes very difficult in our submission to reconcile.
So would it really be in two stages then? I mean, would the conflict arise because, keeping with influence for a minute,
Yes.
you would say an assessment of influence has to play into an assessment of competence.
Well, it plays into an assessment of competence.
Right.
And then also, if the guardian, if a solicitor guardian has an obligation or an entitlement to offer opinion evidence by way of an analysis of their client's position. It plays into their evidence and analysis in relation to child's objections too.
Yes, I was more thinking that if you felt that the child was influenced to the sort of extent you're talking about, you would say therefore the child doesn't have the competence because they're not their own views. They've been pasted onto them by the retaining parent.
Well, Lady, we certainly say that's what should happen.
And therefore, therefore the solicitor would say, this child isn't competent to give me instructions.
Or the judge might. But yes, if that were identified and dealt with at the first stage, that would be the consequence. You wouldn't end up in this situation because there would have been a proper appraisal at the start of the child's competence to give instructions based upon the influence that they've been subjected to.
I'm just trying to tease out how much there is in fact likely to be a conflict, because the red flags really would be at stage 1 competence, wouldn't they?
If things proceeded in the way that I'd set out earlier, where all of this was identified at the beginning, yes. The problem we have in this case is that isn't what happened.
So I'm just trying to strip out
Yes,
what I understand what you're saying about this case, but you also are helping us with the broader issues.
Well, Lady, indeed. If that were dealt with at the start, then this problem would not arise.
Then there isn't. I suppose there might be an academic risk or a theoretical risk of there being a conflict. It's very unlikely if the solicitor has had a proper opportunity and given sufficient information to make a determination of the level of influence and the impact on competence.
Indeed. As I've said, I accept, and the ideal would be that that would happen. Where it doesn't happen, then this problem comes to pass. Of course, another way of dealing with that potential conflict is removing from the solicitor guardian the role of analysis and offering opinion evidence on the material or the evidence that they've gathered, because they could be limited to the role of obtaining their client's instructions and reporting those to the court, and then advocating on the basis of the instructions that they've received, just in the way that we all are when dealing with parents. Of course, it's not terribly likely, is it, that an advocate on behalf of a parent would advance an opinion as to the credibility of their instructions, but that is the role that a solicitor guardian is placed in when advancing an opinion on the instructions they've received from the child. So if it were to be, as the ALC, I think in its submission suggests, that the solicitor guardian were confined really to an advocacy role, with the part of the case that requires opinion and analysis left to professional social workers who undoubtedly have training, experience and qualifications in doing so, it would also remove this difficulty, because the solicitor would simply be taking their instructions, putting them into the form of witness evidence and advancing it to the court.
But you're not saying, are you, that the solicitor is deprived of giving opinion evidence as to competence?
No. I mean,
so there really are two. I know I keep pushing back on this. But
yes.
That there really are two stages, aren't there?
There are. Of course, we know that opinion evidence as to competence is required, and that's dealt with within the guidance that the ALC makes reference to. It's the second stage where opinion and analysis is offered in relation to a defence, particularly the child's objections defence, that the potential difficulty arises, and did arise in our submission in this case.
It's a boundary that can be very blurred.
Well, I think, my lady, that, and
inevitably.
Yes, inevitably, and I think if I understood his submissions correctly, Mr. Turner was saying the same. One of the real problems that we face as we stand here or sit here today is that in WF, the case before Mr. Justice Baker, this idea of appointing a solicitor as a guardian was arrived at only really because the child solicitor, Miss Hanson, had been acting as a solicitor directly instructed for a considerable period, and it was identified, I can't now remember by who, at the final hearing, that the rules didn't actually allow for that. And so the appointment of Miss Hanson as the child solicitor and guardian was arrived at by the judge as a convenient solution to regularise that position. Of course, Mr. Justice Baker then invited the Rules Committee to consider that and really to deal with it. But nothing seems to have happened in that regard. The rules were completely overhauled. The Family Procedure Rules 2010 came in and the position was the same. And as we find ourselves before this court today, there isn't really anywhere where there is guidance for solicitors in this position as to how they should conduct themselves, what the limitations are of their role, whether they should be analysing the instructions they receive and advancing opinions on the basis of it or not. The guidance that does exist, for example, the guidance for solicitors in public law cases, suggests very firmly against that, because that is a social work role, essentially. The point is made that that's for public law cases and not for these, but it's quite a clear statement of principle as to where a solicitor's role ends and a social worker's role begins. And this is why this whole appeal and the arguments within it can be advanced on the basis that there isn't really anyone that is at fault for anything here. It is just a confused situation that has arisen because of a lacuna in the rules that was identified, I think, 12 years or so ago, that has never been filled.
Well, except that it applies, I mean, as we've seen, the rules permit somebody other than a CAFCAS officer or the OS to be appointed as guardian.
Yes.
So it would arise in any case in which somebody other than the CAFCAS officer or solicitor were appointed as guardian.
Indeed, but I'm terribly sorry.
No, and the practice, we're told, has developed, not only in Hague cases but in other areas, for the solicitor guardian appointed on behalf of the child to express views as to strength, background, to give what we're calling, for the purposes of this hearing, opinion evidence.
Oh, my Lord, I have not had experience of a case in any other context where this has happened.
Other than Hague.
Other than Hague.
But it has happened in Hague.
It certainly has happened in Hague. I'm not at all doubting what Mr. Turner says about that. Obviously, his experiences of mine are different, and his are rather longer than mine are.
He'll thank you for that.
But it certainly happens in Hague cases. But if any other person...
Now, I understand you're saying it's confused, and that there's obviously, there might be justification for this being looked at by the President setting up a committee or something along those lines. But bringing it back to this case, your case, Mr. Netto's evidence was in the statements and was admissible evidence.
Yes, and the judge admitted it. So, my Lord, I'm not... Well, there is a distinction which the judge identified and which I can come on to.
But sorry, just getting back to what I was saying before, your submission was that it's confused. There's the role of solicitor guardian has never been properly in Hague cases. Acting for a child has never been properly looked at, and it would merit from being properly looked at.
Indeed. And just lastly, in relation to that, as the rules provide for really any person that the court permits to do so, to act in the role of a guardian, that doesn't necessarily deal with the particular issue that arises with solicitor guardians, because for example, a well-meaning family friend who might be appointed in that role because there's nobody else that could do it, in the same way that sometimes a litigation friend is, would not be subject to the possibly competing duties of a solicitor on the one hand to advise and advocate on behalf of their client, and a guardian on the other who has to provide evidence to the court. And that's why I was going to the example here of the child's instructions. I have not been influenced, and the evidence which suggests really very strongly the other way. Because what is a solicitor guardian in that context supposed to do? If they advance an opinion that in fact, contrary to their instructions, it looks like there has been significant influence here, they would find themselves in difficulty with their client because they're not following their instructions anymore.
That goes back to what I was saying. That would go to the competence, so you'd never get past first post.
And yet here we are.
But of course, Mr. Netto didn't have the benefit of the evidence.
No.
I'm not saying he would have reached a different decision. He might or he might not. But I mean, he didn't have the evidence.
Indeed. My lady, we entirely accept that. And that was the starting point of the submissions that I was making. But that's the distinction between any other person who might be appointed under the rules and a solicitor, which gives rise to a particular difficulty in this context because of the professional obligations and rules that apply in both situations that don't really act the same way if it's any other person. Just to, because I suspect I won't have the time to go luxuriously through the judgment that I thought I might, to make the general point, as I started with earlier and in relation to some of the discussions we've just had, the judge wasn't asked in this case to exclude Mr. Netto's evidence. That was never part of the case advanced on behalf of the mother. What he was asked to do was to consider what weight should be afforded to Mr. Netto's evidence as compared to the Kafkas officer's evidence, and to prefer, because of her experience, qualifications and training, but also because of the particular evidence that she gave in relation to the child's experience of the pressure that he felt from his father, to prefer the Kafkas officer's evidence on the particular point of influence. And when one boils the judgment down, that is exactly what the judge did in our submission. And it's probably most convenient just to deal with that on the basis of headings, because you have read and perhaps will read again the contents of the particular parts. And again, I mean, this may prove unhelpful, but starting at paragraph 20 of the approved note, which is under the heading Evidence of Miss Cole Fitzpatrick.
Paragraph 19.
Paragraph 19, thank you.
I will act as your junior so far as paragraph numbers are concerned, Mr. Green.
I was receiving that information from both in front and behind. So,
we are an echo of each other.
indeed, indeed. We have there the judge's summary of the evidence that the Kafkas officer gave and her view over the course of the relevant paragraphs that the child had been subject to, as the judge termed her evidence, relentless pressure from the father, who was described as being highly manipulative, including through messages that the Kafkas officer agreed were shocking, to the point where the Kafkas officer expressed her concern about the long-term impact on the child of the situation that she considered it he was facing. She did not consider, on the basis of the interview that she held at that point in time, that the child's objection was strong. She did think he objected, but it wasn't a strong objection.
Which paragraph's that?
20.
In the middle of 21? Is that what you were referring to?
Yes.
Yeah.
The middle sentence. She said it was not a strong objection,
Yes.
but that he would prefer to stay here.
Yes.
Not as strong as some other children she had come across, and she considered that was because of his establishment in a community in country X. The Kafkas officer had learned from the child that the father had denigrated the mother to the child, describing her as mentally ill and a trailing spouse. No evidence that the father would promote a relationship with the mother. And then, perhaps particularly relevantly, what for me is paragraph 23, she was asked about some of Mr. Netto's evidence where he, Mr. Netto, recorded the child saying that the father was a bit of a drama queen, and offered the opinion that the child didn't present to her as a confident young person who was able to stand up to his mother or his father. The decision had been influenced by the father, But it wasn't a decision that the father had made for him, and that became the talk of whether the child had parroted the father's views or not. The most important thing for the child was for his parents to live close together, but he thought the only way that could happen was by the mother moving to England, in which case he thought if she lived close by he could have a relationship with both of them. He then goes on to deal in the following section, which I presume for you is beginning at paragraph 24, for me 25, with Mr. Netto's evidence, including the point about the father being a drama queen, Mr. Netto's description of the child seeming completely unperturbed and unfazed, and the description of the father when he delivered what the judge later described as an unacceptable ultimatum, that if the child went back to Singapore he wouldn't see his father for several years. The suggestion that the father was there being rather dramatic, and Mr. Netto's opinion that the child had taken the messages that the judge later sets out at paragraph 60 with a pinch of salt. There isn't any need to consider the judge's views of the other exceptions to return that the father pleaded, and one can turn to section 6A, which has the heading, for me, Solicitor Guardian Opinion Evidence, and begins at paragraph, for me, paragraph 36, James Netto is a partner of a specialist law firm in London. The judge deals there at what for me is paragraph 42 with opinions that he identified in Mr. Netto's statements. The paragraph begins, relevant opinions can be found in, and he sets those out. He deals thereafter with some of the law in relation to opinions from experts. And what for me is paragraph 47, he deals with observations made by Mr. Justice MacDonald in Ciccone and Ritchie, where Mr. Justice MacDonald suggested that the task of assessing matters such as welfare and authenticity is properly with the Kafkas officer. And then, and this in our submission is the important part in this regard, at paragraph, for me, 51 onwards, begins thus, how is it that Mr. Netto is qualified? He deals with some of the evidence that was given and the judge's analysis of that, which is directly relevant to the weight of some of it. And this was with particular reference to the suggestion that the child had treated the messages that are detailed at paragraph 60 with a pinch of salt. A suggestion that the judge found unsustainable.
The judge prior to that had gone through a number of decisions, including that of Mr. Justice MacDonald,
Yes.
in which he had said it's properly the task of a Kafkas officer to deal with objections. He hadn't said that a solicitor guardian or somebody appointed, the solicitor who's appointed a guardian is not qualified to give an opinion.
No.
And the judge in paragraph 51 says that he is not qualified. He, Mr. Netto, is not qualified to give an opinion about influence. What's your submission on that?
Well, the Lord,
And that's is that a fair analysis? That he's not qualified?
Well, there's a particular example of this which we'll come to in a couple of paragraphs' time. But in my submission, the judge was drawing a distinction between a CAFCAS officer who has specialist training, a social work degree, and experience in terms of obtaining and analysing the views of children, and Mr. Netto, who, whilst a very qualified and eminent lawyer, does not have an equivalent social work qualification or other specialist qualification that assists him in interpreting and analysing things that children say. Well, let me find the particular paragraph that I'm referring to. If we look at paragraph 57, maybe for you, paragraph 56, begins, Mr. Netto accepts that.
Yeah, thank you.
So he identifies there Mr. Netto's acceptance that he doesn't have training or qualifications in social work or child psychology, accepts that it's perfectly proper for Mr. Netto to relay to the court the vehemence with which a child expressed his opinion, which was a matter of some of Mr. Turner's submissions before lunch. Of course, a solicitor who takes opinions from a child can comment as a matter of fact on how they present when they give them, but doesn't accept that he is able to provide a psychological interpretation of why the child holds that opinion. So, taking the particular context in discussions with the child about the messages, it may be entirely within a solicitor's gift to say that during that discussion the child didn't seem upset or perturbed or flustered, and that may be relevant to an interpretation in due course as to the extent to which those messages affected them. I only say may because, of course, there are other things that would suggest to the contrary. I mean, if the child appears perfectly at ease discussing messages in February 2023 that in September of 2022 he said had made him feel suicidal, then it may be that his reaction in September 2022 is more reliable than how he presents 6 months later. But, my lord, in this particular regard, in my submission, the judge is entirely correct. Mr. Netto is able to speak to this child, another child who instructs him, to ascertain their wishes and feelings and to advance those wishes and feelings to the court. He is, of course, able to comment upon how the child presents during the course of that meeting. These are all matters of fact that are observable by him. But what is of direct relevance to the weight that the court affords to anything else that Mr. Netto might opine, or any other solicitor in this particular context, is his qualification to do it. And if an opinion is advanced that, in the opinion of the person, in the opinion of Mr. Netto, for example, messages that for all the world seem to have had a significant and traumatic effect on a child did not do so, then the judge is entirely right, in my submission, to say that Mr. Netto is not qualified to advance that opinion. And that stems really from this same point. On what basis was Mr. Netto able to say that the child took these messages, so obviously deeply affecting of him, with a pinch of salt? And that is not something, with all respect to Mr. Netto and his very considerable experience in the field of international child abduction as a solicitor, that he has any qualification to give an opinion on at all. Miss Cole Fitzpatrick is arguably in a different position, because she does have relevant qualification and expertise as a social worker. But she didn't, of course, give that evidence. She thought that those messages were shocking and appalling and had a profound effect. And this is all relevant then to the judge's ultimate decision about what weight can be given to these two people's evidence in the circumstances. Can I come on to that, just touching briefly on, because it was the subject of some submissions earlier, the heading of authenticity must be linked, in my submission, to Baroness Hale's comments in Re-M about whether the child's views are authentic in that they're really her own. I think it's paragraph 47 of Re-M. I won't take time by going to it, but in the context of discretion, that is a relevant feature. And the judge had directed himself to Re-M because it's quoted within the summary drawn from Re-HK, Mr. Justice MacDonald, that the judge quoted at the beginning of his judgment. So I wouldn't accept, if a point is made of this, that there's anything in relation to the use of authenticity. It's just a phrase drawn from the authority that is relevant to an assessment of the child's views. And it is plain from the chronology, history of the messages that the judge then sets out that he was very, very concerned about the impact that all of that had upon this child. His conclusion is stated at paragraph, and this is where our paragraph numbers will diverge wildly, I'm afraid, but at the bottom of the section where he's recounting the terms of the messages, at what for me is paragraph 74, there's a paragraph that begins, that is an account of just some of the messages in this case. Paragraph 97 for you, I think.
Thank you.
And the judge concludes there that the father has used emotional manipulation to try to put pressure on this child. Of course, in that regard, the judge's finding is entirely consistent with the finding made by the court in Singapore about this father's behaviour. He's used the inducement of material goods, he's threatened sanctions, he's imposed sanctions, he's put enormous pressure on him. It is unsurprising that the Kafkas officer concluded that these messages were inappropriate and not child-centric. And then the point at the end of that paragraph about Mr. Netto's assessment is potentially relevant. The court found that the messages were shocking. The judge, this is the next paragraph, there is no doubt in the court's mind that the approach of the father has heavily influenced the child in his decision. The father made a threat if the child went back to country X, it would lead to the loss of the relationship for several years. Here is a resonating echo of that previous course of conduct intended to get the child to do as the father wishes and relocate to England with him. The paragraph that follows, for me, paragraph 76, the judge deals with Miss Cole Fitzpatrick's evidence about that and the impact on the basis of her evidence that all of it would have had on the child. And then finally, the judge's conclusion at paragraph 77. The court concludes that the child's decision to stay and his wishes and feelings about it are heavily influenced by the pressure and emotional manipulation of his father. There had been relentless pressure, which was highly manipulative. All of this cumulatively has been a major contributory factor in the evolution of the child's views. And then the judge carries on to factor that in to his overall decision about objections, finding that the child does object, and then under the heading relevant factors, section 6E, having concluded that there was no welfare risk in relation to a return, he identifies factors for and against.
Sorry, what paragraph?
115.
For me, 92. 114.
Thank you.
Thank you. And at what might be 117, for me, paragraph 94, he deals with the exercise of discretion, identifying that discretion is at large, wide and highly fact and circumstance specific, and so considers the factors side by side holistically, as he puts it. With the strong conclusion in my submission that what for me is paragraph 98, that this decision to order return was not a marginal call, but clear and multifactorial, with a significant contribution from the father's influence amongst other factors that the court has been at pains to identify and evaluate. So, my lady and my lords, in my submission, the judge engaged in what he was fundamentally required to do, having accepted that Mr. Netto was entitled to give opinion evidence, which is to weigh that evidence as against the Kafkas officer's evidence and decide which he preferred. And for the reasons that he gives, all of which in our submission are entirely unimpeachable, reached a clear conclusion that where there was a difference of opinion about the influence that this child had been subjected to by his father, the Kafkas officer's evidence was to be preferred, that the child had been heavily influenced, and that that was a factor, a significant factor, but not the only factor, in his decision, having decided that the child objects to order return in the exercise of his discretion. And in my submission, when one looks at the conduct of this father, that conclusion was not only right, and certainly not wrong, it was inevitable. Because it's completely obvious from the messages and from the father's conduct during the course of the child's stay here in January that the child was subjected to influence by him, not just in January, but as a course of conduct that had extended over years, which had had an ongoing and deleterious effect on the child. And the child was saying so himself to his father, asking for peace, to be left alone and not to be subjected to that. And then he comes here, and he's not having to deal with it anymore. I mean, the lady and my lord might recall, and I can't remember, we'll find it if it becomes necessary, but there was a judgment, I think, of Lord Justice Thorpe that made reference in the context of abduction to the bubble of respite that a child enters into after an abduction. And that is what this child must have experienced, because having gone from repeated horrible messages from his father, he was spared that here. He didn't have to deal with his father's pressure once he succumbed to it. He didn't have to deal with his mother because his mother was cut out. He went into the school that he's in, didn't have to deal with all these pressures anymore. So he found respite, but the only way he could find it was by succumbing to what his father was doing. And in those circumstances, of course, the judge was right to find that the Kafkas officer was right in her assessment. And he was right to factor that in the way that he did. And the rest of his discretionary analysis was unimpeachable, in my respectful submission. Against this background, of course, the courts in Singapore are a better place to continue to decide issues about this child. They have been for years. As was pointed out in the first statement filed on the mother's behalf by the solicitor, there was a hearing in Singapore in February 2023, at which the mother's position is the father continued to advance his case for sole custody. But the court in Singapore stayed it until the father made a payment of $28,000 into court on account of costs that he had been ordered to pay but hadn't. So those proceedings remain and they're stayed. And it's the father's application for custody that is extant in that court and hasn't been dealt with. So on a discretionary analysis, it all points in our submission one way. The judge was obviously correct. And he dealt with Mr. Netto's evidence, having expressed real concerns about the general practice of solicitor guardians. He dealt with it in an appropriate way because he accepted it and he allocated weight to it and he factored it into his overall analysis on that basis. You just forgive me for one moment. We have within the skeleton argument dealt with the specific grounds of appeal at paragraph 39 for ground 1, and then following on paragraph 45 for ground 2, and 52 for ground 3, and we maintain those submissions in relation to the specific grounds. It's not accepted at all that what this judge did was to silence or otherwise stifle this child. The judge had a great deal of evidence about what the child had to say, and he took it into account, and he dealt with it. I haven't been through the particular paragraphs, but it can be seen from the judgment. He dealt with it in stages in terms of what the child said to the CAFCAS officer for the purposes of the CAFCAS interview in March, and why it might have been that the child's views were expressed differently when the child met with Mr. Netto a month later in, I think, April. So he took fully on board what the child was saying, but he made an assessment of why it was the child was saying those things. And of course he was required to do that for the purposes of the discretionary exercise. That's what Re-M in the House of Lords at paragraph 47 says. So he dealt with it in accordance with the law, taking into account all of the relevant evidence. Can I turn my back very quickly?
Of course.
Is there anything further that I can assist with?
No, thank you very much, Mr. Gresham. That's most helpful. Now, change of personnel, I think. Now, would it be helpful if we rose for a couple of moments while people
Yes.
get themselves organised?
It was tasked to me to invite the court to do that, and I forgot. So I'm very sorry.
So lucky you've had me as your junior. We'll rise. We'll give you 5 minutes.
Coming here.
Yeah.
Ruth, try and leave the other lectern there.
Leave anything like
But you need to keep the file in between, or otherwise it will drop down. It'll collapse.
Okay, thank you, good hint.
There's nothing in the file, it's just there as a...
Grand, thank you very much for the info. Katie, do you want to come up here? Yeah, there. I can see that, you know. I think that one. Keep it quiet. Yeah. Oh no, is your...
Welcome to the substitute bench. I don't know why he wasn't sitting at the front there or staring.
Breathe. Do you want that? No thanks, I don't. No, because it's only an hour or so. Shit. God, that sounded bad.
Yeah, yeah.
Court rise if able.
Yes, Miss Lady, good afternoon. I'm the appellant in the second appeal, and I am leading Miss Cameron Douglas, who has represented my client, the appellant father, throughout most of the recent parts of the litigation, the Hague litigation, and also assisted by Miss Best, who isn't in court today, but hopes to join us tomorrow. My lady, can I start by referring to the issue of why the Solicitor Guardian isn't an expert or can't give expert opinion evidence? We put it in the skeleton on behalf of the father for the rehearing at
you don't need to look at it, a PDF 66 in the supplemental bundle at paragraph 40. And we said, though she has many talents, Miss Broadley is a solicitor, not a social worker or a child psychologist. She also has not had the opportunity of interviewing either the parents or of speaking to Amelia's friends, grandparents in previous school. This would entail an appropriate welfare inquiry, as would happen in a relocation case and not for an abduction case. She wasn't present when Miss Callahan spoke with Amelia. Amelia obviously was hopeful of persuading Miss Callahan at her interview, but perhaps had not been properly briefed in advance as to the scale of what was needed.
There seems to be some agitation behind you.
You were using the name.
Sorry.
You read out the name.
Thank you. I apologise. Yes, sorry, because it's a quote. I'm so sorry. Yes. As far as the role of the solicitor guardian is concerned, I think it's in Mr. Hames's document that he says that we attack on behalf of the father the existence of a solicitor guardian. That's not what we're doing at all. Although it has become a more popular role and a more commonly occurring role in Hague cases in recent years, as has already been pointed out, it is a misnomer of a type, because a guardian historically and in all other contexts is somebody who has appropriate qualifications in terms of understanding children, interviewing children, and has studied in a way that we as lawyers don't. And we as family lawyers do tend to think that we can figure out what a social worker would say about things. That's a bad habit that we have, but actually they bring some very valuable information and expertise to the family courts. And in this context of Hague cases, where you have children who have already been abducted and therefore suffered harm, it's of the utmost importance, and I will leave it to the ALC to argue, as they appear to be intending to argue, why there is a need to protect children and to have very clear practice guidance for solicitor guardians as to their role and as to the, if appropriate, training for interviewing children. But ultimately, even if all of that were to happen, they would still be in a position of conflict as solicitor guardians, because on the one hand, they are solicitor advocates. They have a job to advocate on behalf of their client, who is the child or young person. On the other, they are, as you've heard, they have developed a practice which we say is inappropriate, of providing their opinions and their impressions. And those opinions and impressions are not just layperson opinions and impressions, but they have the flavour of social work expert impressions and opinions. And I will take the court to some examples of where Miss Broadley does that. And all of the submissions that I make on behalf of our client are not in any way intended as criticism of Miss Broadley herself, but rather of the practice that has grown up, where solicitors are tactically approached one way or another by often a parent who thinks they're going to lose, as in Appeal A, and in our case, a parent who has already lost. So they are immediately brought into a situation of conflict, because, and one that they're not qualified to be in the second capacity. They're expected to be as guardians, which is looking at it from an objective child-focused point of view. It's almost impossible to divorce the two, one from the other, and then act in both capacities. And that is the difficulty that Mr. Netto in the first appeal and Miss Broadley in this appeal have encountered, because they have sought to, and in our case successfully persuaded the court that they are equivalent to Kafka's. And that can't be right, because as a matter of training, they're better qualified and differently qualified to family lawyers. And as a matter of expertise, they see many more abducted children. And what happened after Mr. Justice Baker, as he then was, recognised or accidentally created the role of Solicitor Guardian, because Miss Hanson had already been in that role. What has happened is that they have wandered into an area that in which they don't belong. And in our case, as you know, we had the evidence from Kafka's about what the child had said, X, and then we had exactly the same substance from Miss Broadley only 2 months later. And whereas Kafka's had said clearly the child shouldn't be joined, there was no need. She was asked specifically about the child being joined as a party, and she said no, there was no need, it would add nothing. Whereas Miss Broadley, only 2 months later, is dealing with a situation where she says, and she says in terms in her statement, Kafka's didn't capture the strength of feeling that that X had. And what she doesn't cover is what's happened in the meantime. So she criticises, in effect, the job done by Kafka's and says she didn't capture it. I've done it much better because I've developed a rapport. And Kafka's aren't given the opportunity to reply to that, or indeed to go back and see whether things have changed. Because whereas Kafka's at the January interview found that, or she believed, Miss Callahan, that X had aligned herself with the mother, she didn't say that she had been coached. But by the time we get to Miss Broadley's statement 2 months later, Miss Broadley seeks to adopt the part of Kafka's that she likes, which is no coaching. But there's nothing in terms of information as to what happened at the mother's home with X when she was told that there was an order for her return. So what the court in our case didn't know, Mrs.
In that case, just remind me, make sure I'm not getting the facts of the two cases
mixed up.
Intertwined. But aren't I right in saying that actually in the case we're now dealing with, one of the difficulties for the child had been that the mother had been so scrupulous about not involving the child in what was going on, that the child was sort of bereft of information and felt very excluded? Or have I got that wrong?
Well, that is Miss Broadley's case. That's Miss Broadley's case. But
Why did the Kafka's officer say that was wrong? I think that was wrong.
So what happened was that Miss Callahan had seen X and Y on the 10th of January, and Miss Broadley became involved. The decision to return was the 3rd of February. Miss Broadley became involved shortly after that. So Miss Callahan was never asked to go back and comment on what had happened in that 2-month gap.
No, I'm not talking about the gap. I'm talking about in the lead up, in the fact of the proceedings. My understanding was that this, whilst the child aligned herself perhaps emotionally with her mother, this was very unlike the other case in that this was a mother who had not involved her child in the proceedings.
Well, that was never accepted or explored in any kind of objective way.
When you say it wasn't accepted, do you mean
wasn't
that was
accepted.
rejected?
Sorry.
When you say it wasn't accepted, was it disputed or was it just not explored?
It was disputed. So disputed to the extent that the father could dispute it, because obviously he wasn't in the home and he had no contact.
It was the father's case that the mother was influencing and subjugating.
That the mother was likely to have intervened with the child and possibly briefed her. He couldn't say he did brief her, or she was briefed.
So he speculated that there was a possibility that.
Yes, and it was for that reason he was saying that Miss Callahan should go back as an objective, child-focused person and look again at whether X had been influenced. Because to remind you of the mother's case and X's case, was that X overheard the mother crying on the telephone and looking for a place to live in the home country. Whereas there are parts of the evidence that suggest otherwise. In
Well, I
terms
think
of
we need to go into all of that. I just wanted to be clear about whether this was an established influence case. And it is.
it's on a different scale altogether to the proof in the other appeal. Totally different. And the way that it was put on behalf of the father is, I'm not there, I don't have any contact. But the substance of what X said to Kafkas was exactly the same in the Kafkas report, in Miss Broadley's statements, and also in the letter that the child brought to school. And to the extent that there is any suspicion of a script, there is a suspicion that arises because of the huge similarity between those three documents that come a little way apart. So when you look at the objections and the feelings that X expresses about her home country, she's able to be quite positive about her home country when she speaks to Miss Callaghan. But by the time she speaks to Miss Broadley, all the positives have totally evaporated. She has nothing good to say now about her home country. But the substance of the reasons she prefers England and the substance of the reasons she says she doesn't want to go to her home country, they have remained exactly the same. So in terms of a broad picture, Miss Callaghan and Miss Broadley agree that X is articulate, that she is intelligent and mature, and that she expresses her wishes clearly, that she did to both of them. So there was no difference on that. There was a difference, and this is where we take issue with the judge preferring Miss Broadley's evidence ultimately on wishes and feelings to Miss Callaghan's, without giving Miss Callaghan a chance to come back and see Amelia again. Sorry, to see the child again. Amelia,
No.
Just
do try and be very careful about names.
Yes. I'm sorry, it's when I read a document, I'm afraid, whereas, yes, I will. I apologise. Miss Callaghan says about X that she gave the impression, that she didn't give the impression of being coached, but that she had aligned herself with her mother. Miss Broadley gives her opinion that the mother hadn't discussed the proceedings with X and that X didn't know about the proceedings. Miss Callaghan said otherwise 3 months earlier. She said that it was evident that X has not been shielded from the parental dispute, and she's very aware of the proceedings. She also said, as she said to Miss Broadley, she doesn't want to spend any time with her father and she believes it's safer for her mother in England. She said that to Miss Callaghan and then later to Miss Broadley. In terms of her feelings about her father, she was equally clear with both. She told Miss Callaghan the main reason she didn't want to go home was because she didn't want to see her father. She told Miss Broadley the same thing. So there is no real difference between what X says to the two professionals. What is of interest, though, is that in the first statement by Miss Broadley, where she asserts that X doesn't know anything about the proceedings, she does say, and this is at PDF 165, in her first statement, before she gets disclosure of the papers in the proceedings in support of her ex parte application, she says that the child doubts that the relocation case would be done in 2 years were she to return home. That was expert evidence within the first Hague case. and it directly contradicts Miss Broadley's suggestion that X doesn't know about what's going on in the Hague proceedings. She knows that very strange detail for a then 11-year-old. It's also right that much of what X tells Miss Broadley reflects the mother's case, and is difficult to in any way distinguish from the mother's case. And as I say, that's as far as my client is able to go in terms of whether there is influence and or coaching. And it was for that reason, that was one of the reasons that my client asked for the adjournment, so that Kafkas could see X again and see whether she still believed that it was just alignment and not coaching that was behind.
The child is not wholly supportive of her mother, who she feels hasn't been able to protect her. She says so.
Yes, and that is a very interesting development if it's real, because it's not accepted in any way that that is a real position for X. Not for one moment, because Miss Callaghan, the child-centred objective person, assessed that X was very close to her mother.
Well, you can be very close, but feel that in certain circumstances that person may not be able to protect you.
Yes, but my lady, when one looks at what was to be protected against, X had no direct contact with her father at the point that she was interviewed by Miss Callaghan. She had no face-to-face contact with her father for well over a year. When she let me go back on the chronology. She had contact with her father when he was living in the home. He had left the home 2 years before the abduction. She had not had contact at his new home with his mother for that past year. She had, and there was a wealth of independent evidence that she was doing extremely well at school, that she had friends, that she was excelling particularly in maths, that she was very happy at school in her home country. That was something that she totally did not acknowledge with Miss Broadley, but which she had partly acknowledged with Miss Callaghan. So the reason that is important again is it goes to whether, in terms of authenticity, there is whether what X was saying to Miss Broadley was her own authentic views, or whether, as we say, they had been the subject of influence by the mother in this case. The mother had lost the case on the same two defences, risk of grave harm and objections. She didn't appeal that case, but in terms of the chronology, within days of the 3rd of February order, she was at school with a letter. And one of the rather incredible parts of X's case is that she, after the proceedings were over, without any input from her mother, Googled representation by a lawyer.
Can you just tell me why, in the 21st century, for a 13-year-old, them Googling problem is incredible?
Well, firstly, she
I would have thought it was inevitable.
What she was alleged to have Googled was, she was 11, coming up for 12. What she said she had Googled was representation for a child in proceedings that were over, proceedings that had ended. That was accepted by the head teacher as something that she had done. The reason I say that's at least unlikely is that the idea that anybody could be represented in court proceedings by a lawyer after the proceedings are over.
Might just show her that shows the 11-year-old bit. The naivety.
Well, that's one view of it. When looking again at how likely it is that she came to do this off her own bat, which Mrs. Justice Theis accepted she had done.
Are you asking us to go behind the findings of fact made by Mrs. Justice Theis?
Well, yes, because Mrs. Justice Theis prefers the evidence of Miss Broadley to the evidence of Miss Callaghan. And she prefers Miss Broadley's evidence, equating her at the very least to Miss Callaghan. That is one of the main...
You say she was wrong to find that the child did this off her own bat?
Yes. Because, yes, absolutely. Because the proper way to have approached that issue of whether the child's views were her own would have been for Miss Callaghan or another objective person to return and speak to the child again, because she would have been in a position to establish from an objective point of view rather than from an advocate's point of view whether the child had been subjected to influence, because there was a 2-month period between the first interview and the second, and there was a completely different complexion to what X had said to Miss Callaghan versus what she was saying to Miss Broadley. And it was incumbent, in my submission, on the court to have somebody objective rather than a lawyer advocating a cause listen to and ask appropriate questions in a child-focused way along the lines of an ABE interview rather than a client-lawyer interview, which is naturally what a lawyer is inclined to do.
Can we go back a stage just from the two statements from Miss Broadley are dated the 8th of March and the 15th of March. Can you remind me what directions hearings there were after the 15th of March?
There was one on the 16th of March.
There was one on the 16th.
And then there was one, and then the set-aside hearing on the 4th of April.
Right. So the set-aside hearing took place on the basis of the, among other things, the statements from Miss Broadley.
Yes. And
no objection taken to the admission of those statements for the purpose of that hearing.
No.
And no, I suppose you wouldn't necessarily set aside. So it was then set aside, and further directions were given on the 4th of April?
Yes.
Right. And do they include, is that the order that records that no party was asking for a further report from, or the court concluding that no further report was required from Kafkas?
Yes. So that's contained in a recital that the court has determined.
Exactly. By that date, the two statements from Miss Broadley, obviously both available. So, prior to the hearing before the judge, no application had been made for a further report from Kafkas and or for Kafkas to be present if this was, I suppose, perhaps an alternative to give oral evidence. That took place at the hearing. That's my understanding of the history, right?
You're absolutely right. There was a direction given on the... well, firstly, there was the recital on the 4th of April that because the father wasn't seeking separation of the siblings, the court would not, had determined that it would not require a Kafkas report, any further input from Kafkas.
Yes.
But also within that, there was no direction. That wasn't an agreed direction. It was there was a draft order on behalf of the father asking for a report from Kafka. So the court had determined it on the basis there was going to be no separation asked for, and that would be the only purpose of a further Kafka's report. What wasn't covered in that order was any direction for the Miss Callahan to attend the rehearing.
Yes.
And that is a point that we say is an omission by all parties, primarily us, my predecessors of various hues, that it was missed by us. It was also missed by the other parties, because your lordship will be aware in the case of Re B, where the court sets out what happens at a rehearing stage, that it would be unusual to not have, firstly, all the relevant evidence before the court, and secondly, that for a rehearing it would be unusual for for the same witness, the only witness from the first hearing, not to be available to give evidence at the second hearing, especially in light of the changed circumstances that Mrs. Justice Theis found to have existed as a result of Miss Broadley's evidence. So we do say that that was an omission, and that it's different to the point about separation. The attendance of Miss Callahan should have been directed at the set-aside hearing. But in any event, Mrs. Justice Theis allowed, I think it was until the 26th or 8th of April, for the father to say what witnesses he wanted to attend the hearing the following week. As it turns out, Miss Callahan was on leave and couldn't have attended had my then solicitors complied with that direction, which it wasn't complied with, and the first time that her availability was inquired into was the day before the hearing, and it was confirmed late that day that she was on leave. So the date that was set on the 4th of April, which was the 3rd of May for the final 4th of May for the rehearing, Miss Callahan could never have attended anyway, because nobody checked her availability on the 4th of April at the set-aside hearing. But what we say is very important about Miss O'Callaghan's absence from that, from the rehearing, is firstly going with the point of all relevant evidence. It isn't any answer to say, which is said by the respondents in the case, that Miss Callahan had given evidence and the judge had heard her in January. Because firstly, there were different issues that Miss Callahan would have been asked about. And secondly, as a matter of fairness, the father had different representatives who, in any event, nobody could have anticipated the change of circumstances. And what the basic case that the father was running on the rehearing was that there was no change, no change of substance between what Miss Callahan reported and what Miss Broadley was reporting. There was no new objection. There was no new piece of information that Miss Broadley put in either of her statements that would lead to the court to think, my goodness, she really missed out something important there. Because the substance of what's in Miss Callahan's Kafka's report is the same in terms of headings. So I've already mentioned three of them, the maturity, whether they were
You
authentic.
don't need the Kafka's officer to come and give evidence as to whether or not the judge should conclude there has or hasn't been a change of substance. Isn't that for the judge to conclude?
Yes, but on evidence, on appropriate evidence.
How would it help asking the Kafka's officer, do you think there's been a change or not? Because the judge can read the reports. Would that require oral evidence?
Well, yes. There were two different parts to Kafka's. One was her attendance. The other was a supplemental report. So, in terms of attendance, Your Lordship is of course right that we couldn't have said Miss Callahan can help you on whether there's a changed circumstance, because that's a factual matter for the judge. But in terms of whether there had been a real change in X's presentation, that is something that Miss Callaghan, we said, would be able to help. If I can take you to what it was that the father was asking the court to do. It's in the supplemental bundle. And it's in the father's position statement for the hearing on the 5th of May, which is at 90, starts at 93.
Page 93.
93 in the supplemental bundle. And paragraph 3 is on page 94. So this is a document that Mrs. Justice Theis directed be filed overnight on between the first and the second day.
So mine 92 is response document on behalf of the mother, page 92.
Sorry, it's in the supplemental bundle.
Yes,
I think
I'm
that's
in the
the core
supplemental
bundle.
so am I. Page 92 is the document from the mother.
What's the date of your
It's,
is it headed position statement on behalf of the father?
it's 89 of your bundle, I'm told by
89.
Mr. Jarman.
Thank you.
Thank you. Thank you. So, this is the position as stated on the morning that Mrs. Justice Theis heard the case. So these were the 4 areas that we were saying on behalf of the father the court needed in order to decide whether there had been a change of circumstance or not. So you will recall, Your Lordship, having just referred to the recital on the order from the 4th of May, Mrs. Justice Theis had said on the 4th of May it was because the father didn't seek separation that she considered there shouldn't be a supplemental report from Kafkas. Whereas now the father was seeking separation.
Well,
and
asking for it to be considered as a possibility
As a-
whilst
yes,
not
thank you.
seeking it.
Thank you, my lady, to be more
It
accurate.
wasn't, I don't think he was positively advocating it.
He was, thank you, my lady. He was specifically saying he still didn't seek separation, but that he wanted the court to consider whether Y should be treated separately and go back, even if the court acceded to X's desire, strong
We
wish
thought
to
that
remain
that would,
here.
that would make sure that the others went.
Yes, he did, and if Her Ladyship had done what we invited her to do before asking for the adjournment, because to put it in context, my client was desperate for that hearing to be effective, but he had to wait until the previous Friday to learn that the set-aside application for permission to appeal had been unsuccessful. So an appeal had been put in for permission to appeal the decision to set aside the February order. That was unsuccessful from the previous Friday, and the first opportunity he had to speak to his lawyers was the day before this hearing started on the 3rd of May. So his position was, if at all possible, it should still go ahead. But it was an increasingly difficult position to maintain, firstly, when it was discovered that Miss Callaghan absolutely couldn't attend, when her evidence was crucial to the father's case. But then secondly, the absence of, once he decided that he would be willing to countenance separation, in our submission, given that Mrs. Justice Theis had decided that the non-separation of the father on the 4th of April, his position on that was determinative for her as to whether or not to get Kafkas to report again. It follows, therefore, in my submission, that when the father was now asking the court to consider that, the separation of the siblings, the court needed welfare information on both children. And what happened instead is that the court decided to go ahead with the old information from Miss Callaghan and the much newer and, I would submit, dramatic evidence from Miss Broadley.
Dramatic in what respect?
Dramatic in terms of language and description within her statement compared to Miss Callaghan. So Miss Broadley uses adjectives in a way that Miss Callaghan doesn't. And Miss Broadley purports in her statements to give opinions about how strongly ingrained certain ideas that X had were, which in my submission she was not qualified to do because she is not a social worker. But what the father instructed us to do was to seek from the mother and from X what their position would be in the event that Y was ordered to return home and X wasn't. And on behalf of X, we put this in the skeleton argument, on behalf of X it was said she couldn't imagine going back, but she couldn't imagine being separated from Y. On behalf of the mother, Mr. Jarman said his client couldn't answer that question. And we say about that, and it's in this document, the position statement on behalf of the father at the page after the page that you're on, which I think is about page 90. That it's normal practice for an abducting parent to be asked what they would do in the event of an order for return. And in this case, we invited Mrs. Justice Theis to ask the mother to say what she would do. And she didn't do that.
Isn't it like, I completely agree that normally that is a question that's asked, but it's very rare for there to be contemplation of separating the children. So isn't it a rather different question to ask a mother, would you stay with one child in the UK, or would you persuade that child to go back? I mean, when the first you know of it's the morning of the hearing?
Well, firstly,
that's quite a big ask.
Well, my lady, it is a big ask, but this is a mother.
Your children. I'm giving you 10 minutes' notice to work that through.
Well, she had a lot more than 10 minutes because by the second morning she still wasn't willing to say what she would do.
24 hours.
Yes, but my lady, many mothers would say, under no circumstances am I allowing my 5-year-old to go back. And where there is evidence that this mother has really failed repeatedly to put her children's interests first, it was incumbent on her to say, if my children, either of them, is returning home, I will go, or I won't go. And in that instance, my client was willing to come, and he had put forward arrangements for him to be refamiliarized with Y, etc. And that was something else that we were asking the Kafka's comment on, because in effect, what had happened was that the actions of X, whether or not coached into it by her mother, we can't say she was, but there's certainly evidence to suggest that she was much more involved, including Miss Callaghan's evidence, that she was involved in the proceedings, that she did know about the proceedings. But in any event, that she and her wishes were given priority by Mrs. Justice Theis against all of the other factors that Mrs. Justice Theis had considered to be crucially important in deciding to order return back on the 3rd of February. So it was really important then to look at Y separately. And what Y had lost was weekly contact overnight with his father. He had not only lost that, but he wasn't even having video contact with his father. The relationship was about to disappear and has since disappeared. So this is a mother who doesn't have a record for prioritizing her children's interests if one of those interests is to have a relationship with both parents. Because your ladyship says, well, that's a very big decision for a mother to make. But she is not just a normal mother. She's a mother who has 1.5 months or 5 weeks into the last term of primary school for her daughter. Her daughter is doing exceptionally well according to the objective school evidence from her home country. And her mother involves her in a plan, surreptitiously. She couldn't say goodbye to anybody. She couldn't. Y didn't see his father to say goodbye. Suddenly, they're abducted. They're put in temporary accommodation in one city. They're then brought up to live in temporary accommodation in Hackney. They're going to school in Chelsea. It's a total mess for these children. This mother is not a mother who has acted in their interests. And in my submission, it is a reasonable question to say to her, in the event that the court sends one back, what are you going to do? And she should have been in a position to say, I will have to stay here, or I'll make arrangements for one, or I'll bring the other one back, and no question.
So what I'm trying to work out is, how does this impact on the judge's decision? Because the judge couldn't compel her to do it. So
yes.
How does this undermine the judge's judgment?
So what we suggest here is that in the event that the mother can't say, then the judge should have proceeded on the basis that she would return with both of them, that she wouldn't allow them to be separated. Otherwise, she had to have the input from Kafkas on a welfare basis. But she couldn't do everything in favour of the child's wishes, X's wishes, which is what she did. So she firstly said, I'm not having the welfare evidence that you say I need, and that incidentally I thought I needed back on the 4th of April in that recital about separation. So she says, no, you can't have that. On top of that, I'm not going to ask the mother what she would do in the event that I make an order for separation. And rather, I'll give the mother the benefit of the doubt and assume that she would allow separation, and I'll proceed on that basis. And that's what she did. So it was compounding of refusal of the wrong option, because what the father was saying needed to be done is you need appropriate evidence from an objective child-focused person as to the effect on each of these children. Firstly, about the four issues that I've just taken you to. When Mrs. Justice Theis said you can't have that, then she should have, in my submission, based herself on Miss Callaghan's evidence and given Miss Callaghan the benefit of the doubt if she wasn't giving her the opportunity to comment on Miss Broadley's evidence, which she wasn't. Because Miss Broadley had said that Miss Callaghan had failed. That was her in her statement. That Miss Broadley was saying Miss Callaghan didn't capture X's.
Just help with that. So if she had done that, you say she should have gone back to the note I've just made. She should have gone back to Miss Callaghan's evidence. But if she did that, that would have meant she shouldn't have set it aside. Because if she just went on Miss Callaghan, so you'd been refused permission to appeal setting aside. So how could the judge simply proceed on the basis of Miss Callaghan's evidence?
Well, my lady, because it was the only objective expert evidence that she had in front of her. Because the other evidence,
you'd been refused permission to appeal against the set aside.
Well, I absolutely know that, but that was the context. Was that the set aside hearing began at 11:30 one morning and ended at 1:05 in terms of submission. And Lord Justice Baker said in refusing permission that the trial judge was best placed to decide whether there had been a change of circumstance. But when one analyses whether there had been a change of circumstance, all that changed was the expressed strength of the objection. There wasn't a change in terms of substance. And when I addressed Mrs. Justice Theis in May, we went through the list of what Amelia had said. I've mentioned three of them, and I have page references for all of them. But a fourth one was that X said that her father was a bully and things weren't as they appeared. She says that to Callaghan, and then she says it in Miss Broadley's first statement. Describes her father as a man who seems nice on the surface, but isn't really, to both Miss Callaghan and Miss Broadley. Amelia X feels England is her home. That's the fifth thing that she said to both, repeatedly to Miss Broadley and to Miss Callaghan. She said she didn't want to go back to her home country, and that she felt British in every sense. That's something she said to Miss Callaghan, and it's something she said to Miss Broadley. that her home country didn't feel like home. Again, she said that to Miss Callahan, and she said it to Miss Broadley. That her home country was boring. She said it to Miss Callahan and to Miss Broadley. That she told both of them that she didn't have many friends when she moved to the other country. That was contradicted by the objective evidence, but that in a way is beside the point. She told them both, actually one point she didn't tell Miss Callahan, but she did tell Miss Broadley, was that she didn't feel integrated in the other country in the way that she felt here. But that was in Miss Broadley's second statement. But she did say similar ideas, like, I feel very British. What was of interest, and one of the reasons we said that it warranted a repeat visit from Miss Callahan for an objective assessment, was what I said earlier about the evaporation of all things good. So that when Miss Callahan asked X about school, she tried to avoid talking about school in her home country. But then when she did, she said it was fun sometimes. She was able to say it was good. That's in the report at paragraph 13 in the Kafka's report. In terms of her living conditions, she expressed that they were cramped in the other country. She told both Miss Callahan and Miss Broadley that. What was the only other point that we could find between, when you look at the substance rather than the adjectives and the opinions in Miss Broadley's statement, the only other matter of substance was that X's emotional response when asked about a return home was from Miss Callahan. She said, I would start crying because I don't want to go back. That's at paragraph 22. Whereas in Miss Broadley's statement, she reports that X's anxiety and anguish at the prospect of her going back has heightened and changed, so that she's suffering sleepless nights, crying every day, that a resistance to a return and that depth of determination that she won't go back. So that is a much stronger emotional response to the idea of going back. But
I'm still concerned that you're going to set aside. I'm just looking at Mr. Lord Justice Baker's order when he says, I've considered the point made in part of the skeleton argument filed in support of the application that a child's expressed views after return order is made will be different from those expressed before the order. Reality set in, I suppose. And then he goes on, given the judge's thorough understanding of the case, there's no real prospect of the appellate court concluding that she misunderstood or wrongly evaluated the nature and significance of the change of the child's expressed views. It rather feels you're asking me now to, or asking this court now, to go behind that.
It's my fault for suggesting that. What I was dealing with was your ladyship's question to me about why I was saying that Mrs. Justice Theis should have stuck with Miss Callahan's evidence and not preferred Miss Broadley's evidence, because it's about the rehearing. It's not about the set-aside. We were dealing with a successful set-aside, and I'm still dealing with that. But what we were also dealing with was a refusal to have the Kafka's evidence that we said was the only appropriate evidence updated. And instead, what Mrs. Justice Theis did was prefer the evidence of Miss Broadley to the January evidence of Miss Callahan. So what my submission was, and I'm sorry if it seemed like I was trying to rehash the set-aside decision, what we were saying and what I say now is that Miss Broadley shouldn't and couldn't have replaced Miss Callahan, because she is a solicitor and not a child-focused objective person. And we as lawyers will naturally fight our corner for our client. And once Miss Broadley is instructed on behalf of the child, even if she had appropriate qualifications, which she doesn't, she would then be in a position of conflict, because she would be trying to advocate on the one hand and trying to be objective about the child's interests on the other. But even more fundamentally than that, she wasn't looking at or representing Y's interests. There were two children here, not just one. And what Mrs. Justice Theis did was that she preferred Miss Broadley's evidence to Miss Callaghan's evidence on the strength of feeling, without giving Miss Callaghan a right of reply. And then she sacrificed Y in terms of his welfare and information about his welfare by accepting Miss Broadley over Miss Callaghan and not giving Miss Callaghan or Y the opportunity to have appropriate evidence about his welfare. So that's the main reason that we say that that Mrs. Justice Theis was wrong. And you see, we've put into the skeleton argument all of the places where Mrs. Justice Theis prefers the evidence of Miss Broadley to the evidence of Miss Callaghan. Can I just take the court for a moment to the type of language and opinions that I say is not appropriate for a solicitor advocate, and on the broader point of guidance, the court may well wish to give guidance about this to solicitors who have found themselves in practice doing this with all best intentions, but inappropriately, in my submission. So, for example, PDF 156.
Sorry, which document?
Sorry, it's the core bundle.
Oh, you mean your skeleton argument?
No, Miss Broadley's first statement in the proceedings, just to give you an example of the type of language and opinions that are expressed.
So we're in her first?
Her first statement, it's at 156. And paragraph 3. This is a point again that ALC may wish to take up, but you will have seen that in terms of public law guidance, the recommended way forward for solicitors for the child are that they should read the papers before having conversations with the child. And in this case, you'll see at paragraph 3, it starts with she's been instructed in very firm terms that she's not going to return, at the beginning of paragraph 3, distressed at such a prospect, and the intensity of her instructions is increasing every day. It's unclear, but we know, because Miss Broadley tells us, that she had spoken to the child at least 3 times by telephone before making the ex parte application on the 8th of March. And we say that that would not be a good idea for a solicitor to speak on the telephone to a young person when it's unclear as to who is with her, what influence might be exerted on her, etc. And that's all before getting access to the papers. At the middle of that paragraph, she says, I've spoken to her on several occasions. And then the kind of opinion that is scattered throughout starts about 8 lines from the end of paragraph 3. I suspect this belies the true depth and strength of her feelings regarding a return. And then at the last sentence in that paragraph, her fear is very real, as is her anxiety and resistance at returning. Those are not just reports of wishes and feelings. Those are assessments of demeanor, which are not appropriate in my submission for a solicitor. Added to that, paragraph 4, Miss Broadley continues that her mother being unable to protect her from her father is a genuine belief. Again, not qualified to say that, and inappropriate for a solicitor to put that in her statement. then a statement of fact, she did not turn to her mother for guidance on how to instruct a solicitor. She has little confidence or trust in her mother at present. That is a real issue that Kafka should have been asking about. Had there been a fundamental change in the relationship between X and her mother, as opposed to Miss Callahan finding that she had a very close relationship with her mother, had there been that fundamental a change, or is that likely to be relevant to the issue of authenticity? We say it's not a matter for a solicitor to inform the court of that, and for the court to allow itself to be influenced by that. Then we see further down at the end of 157, Miss Broadley says, the last sentence, it's very difficult for X to comprehend and grapple with this. This is about being ordered to return home. Returning to a country where she feels unsafe, which is compounded by her belief that her mother is unable to protect her from her father. Again, that is a obvious expression of expert opinion, which should properly be the province of Kafka and not of the solicitor. Then 158, and this is why we say Miss Callahan should have been given a right of reply. 158, paragraph 7, about 5 lines from the end.
Sorry, paragraph
7. 5 lines from the end. This may have impacted on her ability to communicate with confidence. And this is part of the criticism of, or the speculation that X wasn't able to have her voice heard. Further down at 159, the last sentence, X suffered huge gaps in her learning, which upsets her. That was totally contradicted by the independent evidence from the school and that was in the hearing bundle at the first and second hearings.
Sorry, that's page 159. Where's that?
That's the last sentence. That's factually incorrect.
Sorry, which last sentence? So the indent or the
X, the last sentence on that page. X suffered huge gaps in her learning.
Oh, I see.
Well, I thought she did. I thought she did. I thought she wasn't able to go. I thought there was a COVID issue.
Oh well, she should. But there was online learning, and there were school reports covering the whole period that she was away, and she was excelling in all aspects. So there were no gaps.
Well, save and except for what her head teacher says here, which describes the enormous gaps.
Yes, but what her head teacher says about the gaps was wholly contradicted by the school evidence contemporaneously gathered through the 3 years that they were away and exhibited to my client's statement. So the head teacher can say what she likes about a child that she's just met in November, from November until February, but the evidence, documentary and extensive, doesn't support what that teacher is saying. And also, yes, that's what I'll say about that. Again, paragraph 9, she returns to the issue of X not trusting her mother. And then she expresses the opinion in the last sentence that X's fear of her father's behaviour and ability to frighten her seems genuine.
Well, you've not. It's part that, for understandable reasons, you've not referred to. Miss Callahan, the child was very clear to Miss Callahan about the domestic violence, about what she saw her father doing very regularly, and how scared it made her.
Yes, but that was a perfectly appropriate observation for Miss Callahan to make as a child expert. It wasn't for Miss Broadley, but as it happens, they are ad idem on that particular point. But the important point about that, my lady, is that Mrs. Justice Theis found at the first hearing, having heard from Miss Callahan about that fear, etc., that the protective measures were sufficient. to allow them to go back and to defeat the mother running the 13B defence, and it wasn't raised again at the rehearing. So yes.
Thank you.
Worryingly, and again going to the practice point at the first paragraph on 161, Miss Broadley says her instructions are clear, and that X's instructions, this is the top of the page, X's instructions are becoming more panicked and distressed, and I'm presently very concerned for her well-being. That is a reason for a welfare inquiry on its own. And it is also relevant to the issue of how often Miss Broadley is speaking to X before applying for disclosure of the papers, because that statement is before she makes her application on the, or it is in support of her application for disclosure of the papers. And then her expressions of opinion, etc., are more pronounced, and her use of adjectives in her second statement are notable. So on page 163, and the reason that I say it's important that Miss Broadley's statement is littered with these very strong advocates' language is that they will have influenced the judge, Mrs. Justice Theis, because they're much stronger than one would ever see, for example, in a Kafkas report. Much stronger. And Miss Broadley, with all due respect to her, is not qualified to assess and measure what she is purporting to do. So an example of the adjectives is at on 163, the first sentence in paragraph 4. Very assured, compelling, clear, heartfelt. And then 5 lines down, deep-rooted emotional struggle for her. Again, that's not something that Miss Broadley should be commenting on or is qualified to comment on. And 2 lines down from there, the Hague process is at an emotional level with which she struggles. An emotional level. Then Miss Broadley, again, this is advocacy on her part, where she says that many young people, makes a general statement about that in a specific case, and that's something that one sees in all of these cases where people are seeking to join on behalf of a young person, where the experience of the solicitor is sometimes takes up pages in some of these statements about how practiced they are at representing children in Hague cases. So she makes the advocacy point there at the end of 163 that she has seen many children who are confused, etc. Some have been clearly influenced by a parent, others are simply too young to instruct me. X is not one of those young people. Statement of fact based on her experience in other cases and her assessment of this young person. And I say that is not proper. And then 3 lines down from there, there is immense...
Sorry, I've lost which paragraph are you in now?
Sorry, 5. There is immense anguish and confusion, which X appears to have internalized. That's a psychological assessment or social work. Dealing with it by deflecting away from facing these feelings and memories. Wholly inappropriate for a solicitor's assessment. And then 5 lines down from that, I've spoken to her on a number of occasions, lengthy periods. I wonder whether she deflects as a coping mechanism. This is referring to Kafkas, not, you'll see, the context is at the top there. I note the evidence given by Miss Callahan that she believes X is neither coached nor influenced by her mother. And then she agrees with that and goes on to say that she had deflected when speaking to Kafkas. this is all material which we were asking Ms. Callaghan to be allowed to comment on. But it is right to point out that when we read these statements, we didn't object to the opinion evidence because, as everybody in the family court knows, opinion evidence appears inappropriately in many, many statements. And Mr. Turner, King's Counsel, made the point this morning that parents often put in their opinions, and we're not supposed to put those in. But with an experienced High Court judge in a Hague case, who had already heard the welfare evidence from Ms. Callaghan, we were not to suspect that Mrs. Justice Theis would place reliance in the way she did on these opinions and adjectives and prefer them, crucially, to Miss Callaghan's evidence when Miss Callaghan had not found all of these things when she had seen her in January. And as I say, compounded by the fact that we were asking for Miss Callaghan to go and see X again, and that wasn't being allowed. So, carrying on with Miss Broadley, paragraph 6, the depth and extent of the first sentence of X's wishes and feelings and her objection was not evident when the matter came before this court for final determination, but it is clearly evident now. And again, by way of implied criticism of Miss Callaghan, Miss Broadley in paragraph 8 on page 165, she says, I believe it's important the court understands X's life from her perspective to gain an understanding and put it into context. The way she feels, why she feels that way, why those feelings are so deep-rooted, and why it's so difficult for her to contemplate a return to a place where she never felt integrated, never felt at home, and never felt safe. That is totally at odds with Miss Callaghan's assessment of where X was only 2 months before, emotionally and otherwise. And then there's a whole section on some details of X's life in England and in the other country. And there is nothing of substance in there. That there's more detail, but there's nothing materially important to the court's decision about X and how integrated or not she was in the other country and how she was in this country, as described in the Kafkas report. So again, I'm going back to your ladyship's question about why I say that the judge, if she was refusing to allow Miss Callaghan to go back and get more welfare evidence and get appropriate and necessary, we say, welfare evidence, then she should not have allowed Miss Broadley's evidence to replace Miss Callaghan's, because it was in substance no different. It was just in the presentation that it was different, and Miss Broadley wasn't qualified to make the assessments that she did. It is right that Miss Callaghan could perhaps have looked at the, as well as looking at the issue of separation, she could also have looked at the evidence from the school in the second country, as well as what the school was saying in this country. And there was, as I've referred to a few times, extensive evidence. Can I, to suggest that what X was telling Miss Broadley was completely wrong and that what she told Miss Callaghan was much closer to the truth, which was that she liked school and that it was good. That wasn't obviously what she was then saying. Can I look at what Kafkas told the court on the 4th of April it might be able to help with in terms of an additional report? Because you may recall that Miss Baker, who was then representing X, made a call with the agreement of everyone to the Kafkas High Court team to see whether a new report could be done on time for a hearing at the start of May. And the email from Miss Doyle is in the core bundle at 279. So that was on the day of the set-aside hearing, and with everyone's agreement, she called, and Lauren Doyle is one of the people allocating work at the High Court team. And you'll see that she refers to the discussion and the fact that the first decision has been set aside. And then she queries 3 paragraphs from the end what our role would be reporting on her views, and wonder how she would experience this repeated exercise in addition to meeting with her solicitor guardian to discuss her views within these proceedings. And then she talks about, so that's the downside. But then she goes on to say, and this is what we say is very important, and it was something Kafka was willing to do, and we asked Mrs. Justice Theis to do once separation was raised. It's in the middle of the third last paragraph that starts with "I request." And then she says, if there remains a need for Kafkas to report, there may be consideration given to assessing the views of the older child only, perhaps a limited exercise to reviewing the statement filed by the solicitor guardian, and considering whether their views accord with those that were provided to Kafkas, and whether there are any observations made by the family court advisor regarding the authenticity that the court may wish to consider. And then she offers to complete that piece of work by the 28th of April. So we know that because Mrs. Justice Theis on that date of that email decided that if separation wasn't an issue, she didn't want another report. But by the time we got to the final hearing and Miss Broadley's evidence was in danger of overtaking Miss Callahan's evidence, that this is what we anticipated Miss Callahan doing was, and particularly given the decision that Mrs. Justice Theis came to about authenticity of X's views, we were absolutely wanting an objective, qualified, child-focused person, not her advocate, to look at the authenticity of her views and whether there were things at play other than her own views, because her own views were incredibly similar, as I've said. And for the court's reference, the letter that she brought to the school teacher a few days after the decision of the first decision of Mrs. Justice Theis is at 178 in the core bundle. And it's my submission that there is nothing in that letter that was not said to Kafkas. It's again a type of script. The only difference is that with the passage of time and finding out that she is being sent home, she says that 5 lines down, he's forcing us to come. And I don't want to go there. So those are different. Obviously, she didn't know when she spoke with Miss Callahan that was going to be the order. So that's the only difference. The menu, if you like, is exactly the same as when she spoke with Miss Callahan, and the same substance as the criticisms that she made to Miss Broadley on repeated occasions. Now, one point that arose this morning that I just wanted to address was whether somebody can be, a parent or anyone else can be criticised for putting a child in touch with a solicitor. And it would be, this is more relevant to the practice point, I suppose. There are solicitors who will not see a young person or child unless the parents, both parents, are aware. And those people tend not to be the ones who apply to join Hague cases. But it is a practice which this court might wish to consider as a way that might lead to fewer tactical decisions being made and better welfare decisions being made for children, because this court knows as well as anyone that children being joined into litigation is damaging to them. It's damaging for adults, and it's particularly damaging for children. And in this case, in the rehearing, as I understand it, at the set-aside hearing, X was present throughout that hearing, which was something that no objection was taken to at the time, and it went on for whatever it was, an hour and a half in the morning. Clearly, it's not a good idea. Lord Wilson and others have said the extent to which children are involved or young people should be case managed by the court, and obviously the judgment of the solicitor who is representing the child. But on this case, in the rehearing, the father objected to X being in court, and Mrs. Justice Theis describes this in her judgment. And instructions were taken, advice given, and X didn't come back into court. But the mother's attitude was instructive. She proposed, even after Mrs. Justice Theis expressed her views about X being in court, the mother said she should be in court. And in my submission, that was an important submission, because it demonstrates very clearly that this mother wanted X to be in the middle of the battle between the parents, and is one of those parents who doesn't understand that X is 50% of each of her parents, and to put her in the middle of that battle was unwise. And it is also instructive because it lends weight to the suspicion that the mother briefed this child about the outcome of the proceedings and what the potential applications that she might be able to make might be in terms of a second bite of the cherry using the same defences. Which
the common theme, I think, that you accept to Kafkas, to Miss Broadley, and to her head teacher, and in the letter, is her fundamental objection was her fear of her father because of what she had seen her father routinely do to her mother.
Yes.
By way of violence.
Yes.
Over a substantial period of time.
Yes. Yes, I accept that. And so did Mrs. Justice Theis accept it. And in the normal way, at the hearing in January, Mrs. Justice Theis considered all of that evidence. She considered the protective measures. She took the mother's allegations at their height. She considered all the protective measures by the time of and considered that they were sufficient to defeat a 13B. So there wasn't a change of circumstance. There wasn't a change of information between that first hearing and the second hearing. And when Mrs. Justice Theis addressed 13B in this hearing, it wasn't about domestic abuse. And in fact, that wasn't run at this hearing.
No, but the child said on behalf of the mother and the set-aside, on learning that, notwithstanding that fear that she had expressed, an order was going to be made for her to go back, couldn't handle that.
Well,
and had gone to someone to get help and support. The result of that was a set-aside, and so the change in circumstances which the judge was dealing with, was it not, was that the child, far from as the father had said she's an obedient child, she'll do what she's told, when she was informed that notwithstanding her fear of returning to that country because of her fear of her father, sought other advice, and that was the change of circumstances, that she couldn't face it.
Well, my lady, in order to make good on that as a factual situation at the second hearing, that would be much more acceptable as a finding if Miss Callaghan had spoken with X and been able to contrast what she found in January with what she found in March.
And that's really the heart of your submission.
Yeah, yes, it is, because in terms of whether the heart of the submission is the authenticity of what X was saying to the school teacher and to Miss Broadley, because the substance didn't change, and that's the most important point. The mother's case and X's case about domestic abuse were in no way materially different, and as a matter of fact, it was agreed that there had been no unsupervised contact between X and her father for at least a year before she left, before she was taken. Now, if that's right, she was safe for the year before she left. If she was terrified of the father as she presented to Miss Broadley,
And Miss Callahan.
well, no, the extent of what is said is much, much more when she speaks to Miss Broadley compared to when she speaks to Miss Callahan. And it's the prospect of going back and saying that her mother can't keep her safe when her mother has kept her safe. So what is not known, and this is why we say Miss Callahan could have been a sound vehicle on which to make that finding. If Miss Callahan had gone and asked appropriate questions from a qualified expert point of view and reported objectively to the court, then the father would have been in grave difficulty in going behind or appealing the decision that Mrs. Justice Theis made. But when the court looks at the decision she made, she no longer looks at Miss Callahan in the way that she did in her first judgment. In her first judgment, Mrs. Justice Theis was very impressed and relied wholly on Miss Callahan. But what she did in her second judgment was she replaced Miss Callahan with a solicitor. And that's the basic point. That's the heart of the case, is that she should have had expert evidence. And if the expert evidence said the same as Miss Broadley was saying, then that would have been a sound basis on which to say she was terrified and couldn't handle it. But in fact, there was lots of evidence to suggest that the mother was behind it, like saying that the child didn't know about the proceedings, which is what Miss Broadley says, and then she appearing to know that it takes 2 years to do a relocation. So clearly, Miss Callahan would have been a much more objective and reliable and expert witness, and Miss Broadley wasn't able to fulfil that role, but Mrs. Justice Theis replaced the expert with a solicitor.
25 to 5.
Yes, I see your ladyship. Yes,
Have you completed your submissions?
yes, I think the other points were largely practice points. I think there may be a couple of points that I haven't read.
Well, if you speak kindly to Mr. Jarman, he may allow you to reflect overnight and steal 5 minutes of his precious time tomorrow,
I'd be
or
very
even
grateful.
10 if you speak really nicely.
Thank you. I will do my best to speak extra nicely.
Very well. 10:30, please. Thank you all very much.
Lady, may I simply inquire as to whether tomorrow afternoon would be available? Because the case was originally listed for 1.5 days.
It certainly was.
And I've never, forgive me if I've missed something, but I'm not quite clear whether this court is able and indeed willing to sit beyond the luncheon adjournment, because our timetable, with the interveners having the opportunity to make oral submissions, clearly does extend.
Yes, and I think you should have had a message to that effect.
Yes.
I thought the message had been sent out.
It may have been
I've
I've missed
prepared for all the hearing taking 2 days.
I must say, tipping it into the afternoon didn't really mean 3:30, but we'll
Yes,
see.
well, that's what I wondered.
We'll see how we go.
Thank you.
Thank you all very much.
I'm so grateful. Oh, okay.
And also,
I'm doing great.